Greetings. My name is James Bell. In another segment, we were talking about a juror and the function of a jury. Today, we're going to talk about the other processes of a criminal trial, not a civil trial. Now, as a refresher, you've been told that jurors are summoned to the court and they are questioned by the lawyers. Now, what happens after some of the questioning, a lawyer will challenge a juror at the bench for cause. That is, that the person is not competent to sit on the jury. A habitual drunkard, a mental incapacitated, a person that's got an infirmity of body or mind, and so on and so forth, various statutory regulations. Or the lawyer can strike a person from the panel. It's called a peremptory challenge, just for no reason at all. They don't like the way they walked in the courtroom. They don't like the book they're carrying. One thing or another, maybe their history on previous panels, previous jury service, or they may know a witness. So that being said, the jury is chosen and we move into the next phase of the trial, and that's called the opening statements. That gives the sides to the lawsuit, the criminal lawsuit, state versus the defendant, United States of America versus the defendant, to state forth their evidence of what the so-called coming attractions will be. Those statements generally take about 10-15 minutes. In a few trials, with the permission of the court, I've had a 2-hour opening statement, but it involved a case that went on for 2 weeks. It's pretty complicated and involved 100 witnesses or so, maybe 80, and it was very, so those things are normally short. The prosecution will go first and set out in great detail why the defendant committed the crime for which he's being charged. Now, on further review, we have talked previously about crimes, and that was earlier in the segments. Crimes are made up of elements or parts, like hot buttered popcorn, and the prosecution's got to prove that the popcorn in question was heated, it was buttered, and that it was popcorn. And if all three of those elements coexist at the same time, it's proof of guilt beyond a reasonable doubt. Then they have made their case. The defense don't have to do anything. It's basically to test the trustworthiness of the government or state's case against the accused. So the defendant may, if he chooses to do so, make an opening statement, or he can reserve it to the beginning of his proof, his or her proof. I should say I use he because traditionally that's the way the jury instructions refer to him. So we'll try to be a little bit more gender friendly here. In any event, after the opening statements, the prosecution will open with their witnesses. And as the witnesses begin to testify, you may hear an objection by the defense. What that means is that the defendant objects to the omission of testimony by the witness based on the question or the anticipated response, or it could be both. The court will make a ruling, a legal ruling, and the witness will either have to stop his testimony or proceed with his testimony or otherwise modify his testimony based upon the objection. And then the trial will continue on. After all the witnesses have been presented, then the jury goes out and the defendant will be required to make a motion for judgment of acquittal in that the evidence is insufficient to support or sustain a verdict of guilty beyond a reasonable doubt. Now, a lot of people used to call that a directed verdict, and they call it a motion for judgment of acquittal under Rule 29 of the various rules of procedure, whether it be the federal rule or the state rule of criminal procedure, and the judge will rule upon it. We've had the fortunate occasion in several homicide cases and other cases, paper cases, white-collar cases, for the judge to grant that motion. So that is the first phase of the trial, and in the second portion of it, I'll discuss the second phase of the trial. Thank you very much. If you have any questions or comments, please give us a call at 865-637-2900 or visit our webpage at www.jamesahbell.com. Thank you very much.